to 6 hours of tapes already, and I still have quite a bit more to go. The whole idea, the other day somebody gave me a call. I know somebody this morning, I talked to people, and it seems like my phone rings quite a bit. So it's hard to take the phone calls and also do these cassette tapes sometimes. Sometimes I'll be up real late at night trying to do these tapes so I don't have to take the phone calls. But the thing is, sometimes I don't think people understand the value of an expert witness. Let me go back to when I was valuing and appraising businesses. Usually it was a divorce case and there's a property settlement. Just like if you have a house, you have to divide the value of the house between the husband and wife, same way with the business. And, the husband or wife that own the business, they could walk in, they can say, well, I think this business is worth $1 million. And somebody else says, I think it's only worth $100,000. And usually there was that type of disparity between values between the expert witnesses, because the value of a business is your gut feeling, using formulas that usually don't work. And a husband or wife could come in, they can give their opinion as to value, but the court's not going to listen to it. Why? Because they're not experts. They never bought or sold a business. They don't understand the way to value and appraise a business. They don't understand the different methods. They don't understand the various terminology. Well, see, when you walk in, let's say there's a real court case, and let's say you're being foreclosed on. You have to understand, number one, you are in a military court. They can make up the rules as they go along. They are there because they are to uphold the bankruptcy of the United States. That means the current banking system. It's like walking up to the fox who's guarding the chicken house and saying to the fox, you aren't supposed to be eating the chickens. And the fox knows that's why he's there. He's there to take the plunder, to take the chickens. And he's guarding it just to make sure nobody else is going to eat the chickens, so he gets to eat them. That's really what's going on here. So that fox isn't going to stop eating the chickens unless you embarrass them. And also, they're not going to do it unless you are able to vote them out and tell them get lost and throw them out and tell them they can't be on the premises with chickens. So we have to have the voters have the strength to be able to get this thing turned around by the vote. And they're not going to listen to us. They're not going to give us any credibility unless we have the numbers out there, keep on spreading the numbers, getting the information out and getting it out and getting it out. I know that sometimes it's not easy, but that's how it's really designed, because that's like when you get this course, you get enough books along with it, you can go out and retail the books and virtually get most or all your money back. Same thing with the membership in the club, so you can learn how to go out and buy foreclosed property. And maybe there's no foreclosed property in your area, but you can get a sister club started in another part of the country. So, it could be really good for everybody. And people say, I don't have any money. You don't hardly need anything. You can go out and retail a few books and pull some of that money, from the profits. But people don't understand the value of the expert witness. See, the value is, when I would come in, if the other side did not have an expert witness, and I came in and I gave my belief as to what that value is, the other side couldn't contradict me because they did not have an expert. They have to have an expert to contradict me. They have to have an expert to prove that I'm wrong. And the banks, they know they got a problem. And this is why I've written volume number 1 and volume number 2 the way I did, because I'm trying to show you how to take their expert witness and get them to agree that you are correct. And they know that. And the other thing about the expert witnesses, if we keep on picking up expert witnesses all across the country, it's going to really hurt their banking system and get it turned around to what Abraham Lincoln wanted to do. Because, see, they cannot operate in the light. They cannot operate with people really knowing what's going on. They have to operate in darkness, and that with a sleight of hand, like a magician. And they have to call loans exchanges and exchanges loans, and opposite of money, money, and redefine words and make them mean the opposite of what they really are. So the expert witness can come in and give his belief and say, I believe these are forged documents, and they never loaned 1 cent of legal tender of other depositors' money, and what really happened was repayment of a loan. And the CPA can say that according to the bookkeeping entries. That's it. Policies and procedures. And what he's really going after here is they did not disclose the real cost of this agreement. The real cost is my client had to give the bank $100,000 of actual cash value for free, of which my client lost. The bank returned it not as a return of capital or repayment, but as the opposite, as a loan from the bank back to them, and $100,000 was converted from my client to the banker for free. And the bank got it for free, the actual cash value. Now, the bank went ahead and sold the promissory note, but the people who bought it obviously had full knowledge as to what was going on. And yet they're trying to hide this. Okay? And it's disclosure that your expert's going to be talking about. Now, one of the things that that I'd like to see happen in the future, and I've done some of this in the past myself, but I can't do everything myself. We got to give notices as to what's going on to the sheriff, to the judges, to the attorneys working for the banks, and also to each and every of the big CPA firms and the local CPA firms in your area. Especially if you're working as a club, the local certified public accounting firms are right there in the yellow pages, and you should go right through it, especially the regional firms or the larger firms, and start giving them notices of this fraud. Registered mail, return receipt. You can do a couple a week or something, and other people in the club kind of doing the same thing. Now they are being noticed, and you explain to them. You can even tell them you have a copy of the book if they want to, lend it to them for a week or something. And you could also say we're looking for CPAs who will be expert witnesses against other certified public accountants for giving bad advice. Okay? Because once that CPA takes on that assignment, and if he doesn't have the competence, he's in big trouble. So there's a lot of things you can do with notices. The other thing is, I've in the other 4 cassette tapes, I said, you have to look up the definitions of various words. Now, one of the reasons for that is when you're going to go and you're going to talk to that expert, or you're going to cross another expert on the witness stand, what's going to happen is if he's having any difficulty with you, you're going to read a definition of like the word loan or exchange or whatever right out of Black's Law Dictionary and say, do you agree or disagree with Black's Law Dictionary, the word loan? Do you agree or disagree with Black's Law Dictionary, the word exchange? And you can kind of go right through that, just like that. And he has, now you've really made it difficult for this expert witness. You can go right through the Federal Reserve Bank publications and you say, well, Mr. Expert Witness, according to the Federal Reserve Bank publication, so-and-so is exhibit number 4, paragraph this or whatever says this. Do you disagree or agree with the Federal Reserve Bank publication? See, they got a problem now. So, and then you say, well, here, now I'm going to show you the agreement right here. Where does the agreement agree with an exchange instead of a word loan? See, it's this type of thing. This is how you're going to play with these experts. All right, this time I want to start having some fun with you guys. I mean, we've been going through a lot of information on the other tapes on how to present a logical argument to a seminar or in front of a jury or mock trial or whatever you want to call it. And you got to use the very simplistic approach because the bank, they want to get all sophisticated and complicated and confusion and misunderstanding. And you got to keep the argument so basic, so simple, that they can't refute a thing that you have to say. And in other words, if they loaned you no actual cash value for you signing and agreeing to repay them back, then why do you have to repay them back money? A bank liability has no actual cash value. Only the asset side has the actual cash value, not the liability. And if they're lying to you, even on the witness stand, they got a problem. Now let's just talk about the expert witnessing and the telephone calls that I have received, of people telling me what was going on out there, and my personal knowledge. I have sat through a trial, I sat through deposition, and I have listened to these so-called bankers absolutely, irrefutably lie. And they will lie if they think that you do not know what is going on. And so you want to catch them in the lies, because the more they lie, the more you can show that they probably lied to you in the first place. If they're lying now, they knew what was going on. It's their business. It's their industry. Just like I'm a pilot. I know how to fly an airplane. And if someone were to come to me and talk about airplanes, I could tell a crackpot when I see one, because I know how to fly. I used to teach people how to fly. I'm an expert when it comes to that. But see, a lot of people, if I were to lie about flying, other pilots would have full knowledge that I'm lying. They'd have to know I'm lying. Why? Because it's my field, it's my industry. I understand flying. I understand sailing. And if I'm, with some other sailor and I'm lying about how to sail a sailboat, the other sailor would know about it. Well, I'm going to teach you now about what a CPA has to know in their industry, so that they know that you know. So I'm going to talk about what a CPA has to know as far as the law, what a CPA has to know as far as generally accepted accounting principles and generally accepted auditing standards. And then because I went back and I bought the courses for the continuing education. I'm taking this right out of what the CPA textbooks are. What you have to pass the CPA test or continue to be a certified public accountant. And I have it right in my hands right now, the generally accepted auditing standards for a credit union. And we're going to go over this as we go through these other tapes. So we have a lot of really neat stuff that I want to show you right now, and we want to go over this because I want to show you what I know a CPA has to know. And by having to know this, it's going to benefit you. Because when I'm there in court or I'm listening to these guys, if they think you do not know this, and a lot of times people are out there, and this is why I really hesitate. Sometimes I almost fear putting these cassette tapes together for fear someone's going to take them and start copying them and giving them out to somebody who's trying to make a quick buck, and a lot of people are going to suffer because of it. And it really concerns me. And but I'm going to show you what the CPAs really have to know. And I really believe you really need your own expert witness. And the reason you need your expert witness, because when they walk into court and they go before that judge and that expert says that you are correct, we have testimony now that you are correct. And this guy has specialized knowledge in his field. And the banker now has to either put up or shut up. And they got to put up their expert. And the minute they do, I've already taught you through the written information how to take them and blast them. And if they have given you no actual cash value loan to you to obtain the promissory note, then your question is, why do I have to pay them back? If I have to pay them back their loan, then why aren't they forced to pay me back the unauthorized loan back to me? And that judge has to sit up there now, because you're exposing all this. And if you have your attorney and you have your expert witness and you've exposed all this, that judge isn't going to be real quick to want to say, yeah, we deny you equal protection. You have to loan the bank. They loan it back to you. You got to pay the bank back, but they never ever have to pay you back. They don't have to loan you 1 cent of legal tender. They get all the liens and the whole property, the whole country for free. And there's two classes of citizens, those who steal and those who are the victims of the thief. And you're damaged, but so what? That's the way it is. We don't uphold the Constitution, equal protection under the law, and we don't give you disclosure under the agreement. The judge doesn't want to say that. So now by exposing all this, putting the spotlight on all this, he has a problem. They got to use courtroom procedure to try to shut this thing down before it ever gets to court, and they will try. And that's where you need a good attorney to stop it. That's where you need a good expert witness so to help that attorney to stop this thing being shut down before you ever get in front of that jury. And those guys that think they're going to walk in there pro se by themselves and do this, it's the banker's attorney's job to shut that pro se person down without an attorney and stop that person from getting in front of that jury trial. And I've seen it goes right up until the minute you think you're going to have a jury trial, and boom, they get this thing stopped. And I believe if you had your own attorney, the probability of them getting this thing shut down is greatly decreased if you have your own attorney. I can make no promises. I can make no guarantees. I can only tell you what's been happening in the past. And things will change in the future. And I don't know at what time you're going to be listening to these cassette tapes or not. I don't know that. But I'm trying to give you some logic here. And this is what this whole thing is all about. And this is the other thing too. I don't know how to really say this exactly, but a lot of people, they want to try and steal information. And they want the professionals to go out and give them their time for free. A lot of people call me up all the time, and they're trying to get free information from me, and they'll try and keep me on the phone for a half hour, an hour, 2 hours. I've had people say, well, Tom, we'll give you money, we'll buy your course, we'll be a leader, we'll promote this, we'll promote that, just answer some questions on the phone. And they'll keep me on the phone for 2 hours. And then after I'm on the phone for 2 hours, they say, well, now we got what we want. We're not going to help you, Tom. We're not going to pass anything out. We're just trying to get something for free. Or they're out copying tapes, and then they're trying to make bad case law, because there's some people who will just get a court case. I remember when I was up in Chicago, someone took, basically same arguments that I had, and they filed it, and the story goes that the judge called the banker back into the judge's chambers, and the judge came back out with the bank, told everybody clear the court. Judge left and basically told the bank to settle. Our guy came out with a great big smile on his face. Now there's no evidence of anything, okay? But the thing is, they were taking that court case, and everybody was making copies, and they're trying to go back and refile it. And so, well, if it worked for this guy, it's going to work for you. The people that were filing that court case did not understand banking. The banks would ask certain questions to find out how much, they're probing to find out how much you really know. And people didn't know. The banks would maliciously come back and attack and win because you didn't have enough information to proceed in court. And I see this happening, so people are out there making bad case law. And it makes it much harder for me to continue on when people are out there only doing part of what I say and making really bad case law. So what I see is a lot of times people say, well, gee, for $150 and I got some papers right here, I could file and just see what happens. And if I lose, I lose. I'd lose anyway. Well, I can't stop them from doing that. But this is kind of how it works. When people are not really informed, they really don't know what's going on. It's like breaking into a grocery store and saying, I don't want to pay for anything. And they're out and they're filling up the grocery cart with a bunch of groceries, and they're stealing the groceries and they're breaking down the window to get out of the grocery store. What's going to happen is those people are going to need to go back to the same grocery store to get groceries later. And that grocery store is going to say, no, we won't let you in. Well, the people are trying to steal the information. Says, we don't want to pay for it. We don't want to support the leaders. See, they can go ahead and try and steal, but later on they're going to need the leaders. And the leaders are going to say, and the club members are going to say, nope, you're out of here. We will not work with you anymore. I've actually thrown people out and forbid our people to work with them or give me any new information. So the people are, out there doing this type of thing, they're not going to be able to get any groceries later. If they're not paying for it, then that store cannot support it, and I cannot support it. When people call me and they want me to do stuff for free all the time, I could go out and get a job and go do something else and actually make money. So the whole idea here is these cassette tapes, I want people to get the information, but I'm asking you to get your money back from the course by simply retailing the books out, and that way it gets more information out. As we're getting more information out, we keep on picking up more lawyers and more CPAs. And that's our goal. Our goal is to get these voters woken up. And if you keep on getting lawyers and CPAs, I'm telling you, it's going to get this thing turned around much, much faster. So the whole idea is we got to get the CPAs knowledgeable about this. As I go through about the CPA audit report, you're going to find out if enough CPAs find out about this and find out about the truth, they're going to have to go back and redo those audits. And that's the thing I'm harping on. It's the third time I'm saying this. But if we keep on waking up these CPAs and keep on being able to talk to them logically and show them what's going on, the bookkeeping entries prove what I'm saying. So now I'm going to show you what the CPA has to know as far as background and as far as history. And what I've done is I outlined some things. I went back to the same law books that I had when I was in college. This goes back a number of years. And I pulled out a lot of things that we had to know as far as taking this law course. You had to take a law course on business law. That's like contracts, negotiable instruments, and things like that that CPAs would have to know. And when you go to pass the Certified Public Accounting Test, there's different parts of the test. One is theory, one is auditing, one is accounting, and one is law. And you have to pass all those sections. Well, when the last semester in college, I went to summer school and everything else so I can get all these other things out of the way. And the last semester in college, I took the CPA review course, I took an advanced accounting course, and I took a law course, so that everything's centered around getting that CPA test passed. And I'm going to show you right now information coming right out of the exact information that CPAs are taught, right out of the courses, okay? So from now in the next couple hours, I'm going to be talking about this. And you have to understand this. You have to have some type of a background knowledge. So when you're talking to a CPA, you can talk intelligently. You know what he was taught. You know these different things. Okay? So let's get started. I'm going to talk right now about law. All right. I left a blank right there because I want you to wake up. Okay, wake up, guys. Listen to this. What I'm going to teach you right now comes right out of the law course taught to certified public accountants. And I outline some things right here. Number one, they talk about contracts and agreements. And when you have an agreement, that's a meeting of the minds. In other words, you have to both understand there has to be mutual consent. A contract can be implied, it can be expressed. Expressed is something in writing. Implied, that means by conduct, not necessarily by words. Now, what they don't tell you about is there might be a hidden contract, and that's called that Social Security number, because when you look at these banks, every time you apply for a loan, they want that Social Security number. Take a look at those credit card applications and other things. The credit card number takes you back to Washington, D.C., the 10 square miles, and they ask if you're a U.S. citizen. Some of you people understand what I'm talking about. So Congress can pass the laws they want within the District of Columbia, so they came up with private bank script. And they tried to get all of us enslaved under the federal citizen instead of a state citizen. And some of you people know what I'm talking about, some don't. But that's part of this contract thing and using Federal Reserve notes and the Uniform Commercial Code because we're bankrupt. Now, you know that they've pretty much suspended the Constitution. They only use it if it goes along with their wishes. If it doesn't, they ignore it because they suspend it, and they don't want you to know that we're not really under the United States Constitution like a lot of people think we are. Now, under this law course, I'm going to come back to these contract things later under the Uniform Commercial Code, and we're going to bring out some things. So there's reasons for what I said, okay? Then they come into unconscionable a contract with no reasonable man would agree unless they're under duress or they're tricked or there's delusion or deception. Nowhere would no honest man or fair man would accept a one-sided unreasonable agreement or an unenforceable contract which is breached. Now, in volume number 1, chapter number 8, it says intent of agreement. Now, when you go back and you take a look at that volume, I'm just going to quickly go through it right now. I talk about where it says intent of agreement, the different things you have to have an agreement. And number 1 is an agreement with mutual understanding, competent parties based on approval or willingness of both parties, supported by consideration, that's money. And the lender has to give up money to the borrower, made with a lawful purpose and has legal form. Now, an offer to be valid needs to have contractual intent. In other words, a state of mind. You know where the money's coming from to fund the check, in other words. Number 2, definiteness. Know positively, for sure. Number 3, communicate it. They did not communicate this in the written agreement. They tried to make it appear to be something other than what it really was. So we have a bunch of deception as far as I'm concerned. All right, then the book goes through talking about contract law. They talk about misrepresentation, rescission, concealment, fraud, misstatement of intention, which constitutes fraud when a promise is made and never intended to keep the promise. That's called misstatement of intention. And misstatement of past or present facts is a fraud. So when they take you into court, they're trying to misrepresent past or present facts. They're trying to say, well, we loaned you money. No, you're concealing the fact it was a return of an earlier loan from me to you. And you knew this, even though you bought the promissory note. Talk about undue influence and duress. Is there an oral agreement that you loaned the bank the promissory note? When you take a look at those bank loan agreements, they're going to say that there's no oral agreements. So they can only be what's in writing. So they kind of cook their own goose on that one because it doesn't have it in writing and that you're the depositor, lender, and creditor to the bank to fund the check back to you. Look at the loan agreement. It says no oral agreements. So take a look at that. So only what's in writing is applied, and they didn't talk about stealing or you gifting something to them. Now, the word loan means a delivery by one person to another, a sum of money or an asset upon agreement, expressed or implied. Now, take a look at this under Black's Law Dictionary. It says expressed, that's in writing. Implied, that's the bookkeeping entries. The implied agreement, they recorded a loan from you to them. That's the new bank liability. So we have an implied agreement. There was a loan from us to the bank. Now take a look at a notary. A notary making a false certificate is liable of any loss caused. Now, they're going to have to come back and they're going to have to say, well, we got a signature from you. We got a notary right here saying that you got a signature. You can come back on the notary according to this. I'm just going to tell you what I was taught for a course to become a certified public accountant, check with your attorney and all this. But the thing was saying that there's a notary and they're making a false certificate, they are liable for the loss. So if they're coming back and saying that is your signature and they don't know the difference between signature and handwriting, Handwriting is one thing. A signature gives validity to the document and the transaction. So you're going to notice, you're going to notify that notary that if they do not reply, and you can just add them to the lawsuit because they know that it was a forgery of a document. See, that's the beauty of this thing. So they can always testify at your handwriting, but they have no idea if the thing's been forged. So if there's no notary, so if the notary says it's your signature, and you've noticed the notary of the forgery of the document, then they must undo the notary, providing that you're correct, or you're going to sue them. Now remember, the notary is licensed by state, so you're going to find out their latest address, and you're going to contact them. So it's pretty simple. So you can have a lot of fun with this notary. Now, signature is there to validate a document in a transaction. It's much different than handwriting. Now, a certified public accountant needs a signature to examine and authorization for the bookkeeping entry of the promissory note to be a loan from you to the bank. And this is where the certified public accountant failed the audit, as far as I'm concerned. Now, the bank must accept legal tender or whatever type of form of money that they're willing to accept, which is a check or a demand deposit account. This is why they're going to refuse your second promissory note, but they don't refuse a legal tender or demand deposit account. Now, what is that demand deposit account? That demand deposit account is what? It is nothing more than private bank script. That's private bank money that has no value. Now, they're going to come back and say, well, it does have value because you can get legal tender for it. Okay, how do they get the legal tender to back up this newly created bank liability they're calling bank script or bank money? Where are they going to get the legal tender for it? They get it because they received something from you for free, and that's called a promissory note, and they sold it to get an asset called government bonds or cash to back up the newly created bank liability, which they're calling the bank liability money now. So their money has absolutely no value. Without your promissory note giving it value, so this private bank script called demand deposit account is worthless, has no value, no one will accept it unless there's legal tender behind it. And they got the legal tender from you, the borrower, to give their new bank script the money. So when they say they gave you money, their money had no value unless they took something from you and used that value to give their money value, and then they gave their money back to you. But all the value came from the borrower at all times. So anytime they come back and says, well, we can go ahead and create money, where did the value for that money come from? They're going to say, well, people are willing to accept checks. That's right, they'll accept checks, they'll accept drafts and wire transfers, provided one thing, there's legal tender behind it. Where did they get the legal tender? They got it from selling the promissory note. So you're telling me they got the promissory note for free, they paid no legal tender, they paid no other depositors money. And if they're saying, well, but we gave you bank script, but that bank script had no value. Because there's no, if you just create a bank liability, you can't create a bank liability without an offsetting asset. And what's the offsetting asset? It's the promissory note. The promissory note gave that bank liability the value. So the value for the loan came directly from the borrower, any way you look at it. All right, let's go on. Under this course, this law course, they talk about alteration of a written agreement, and what it was basically saying is it must be a material alteration, must be made by someone in the contract, and that would be the bank. See, they're saying if a stranger altered the document, it has no effect. So if a stranger or a thief altered the promissory note and they deposited it, now we got It means the stamp on the back of the promissory note has no effect, and they could not have deposited, so they're still in the same mess they're in before. It has to say it was intentional, it was not a mistake. Well, it was very intentional because they made up a stamp. They knew exactly what they're doing. That stamp they stamped it with made it material alteration, and they did it without the consent of the other party. Now, if they had the consent of the other party, that's the borrower, then why don't they come into the bank, the court, and they say, yeah, here's the alteration, here's the stamp, we had approval from the borrower, and here's the written, sign off from the borrower saying it was okay for us to alter this. They have never done that in court. They always hide and say, we lost the document. We don't have an original anymore. So they know it was an alteration. And you can't tell me all these lending institutions that have these promissory notes do not have originals of any of these. You can't tell me that and have me believe it. Okay, they can track it down. In fact, the best thing you could do is when you do pay off a loan is to force them to give you back that promissory note. You know what they've actually done in the past? People have gone in there with cash, paid it off, gotten a receipt that they gave them the cash, and then 5 years later, after the whole promissory note's paid off, the bank comes back and forecloses on them and takes their house. We have stories of this. And the judge says, well, prove that you paid them off. And by the time you've lost the receipt or you lost the check. And the banks, they take the house, because if you don't get that promissory note back, they can use it to come take your house, and they have done it time and time again. That's why they don't give you back the promissory note. And they use it, they keep on using it just like it's money. So if you really want to hurt them, get that promissory note back, because it makes them lose a bunch of money in the process. All right, let's go into negotiable instruments. They talk about that. It has to be in writing. It has to be signed by the maker or the drawer. Be a promise or order to pay money. Unconditional. To pay money, not credit. See, it says to pay money. You got to pick up on these little words. It doesn't say credit. Credit's the postponement for the payment of money. Money means legal tender. Money means a bank asset. It says a certain sum of money or some certain. Be payable at a certain time or in demand. Payable to order or bear. And if payable to drawee must give ID or show that he is the real person to be paid. That sounds like a check, doesn't it? But it can also be a promissory note. Promissory notes, some people say, are commercial paper. Some say it's a negotiable instrument. Basically the same. Just to look up the word, you can look up under the law, commercial paper versus negotiable instrument. There is a little difference. All right, it goes on. It says, bank can endorse an instrument to be deposited. That's exactly what they did. They endorsed it, boom, with a stamp, paid the order up, and made a deposit. Now, they can say it's not really a deposit, it's an exchange, because the promissory note funds the check. I don't care what they call it. It has the same net economic effect, same bookkeeping entries for the net end result. The next thing it says, the problem is the bank endorsed the promissory note, deposited, but it never showed the deposit as a checking account balance statement to the borrower. In other words, if you're the borrower and you brought something to the bank and you deposited the promissory note and they withdrew the funds and gave it back to you, they never showed you a bank statement like that with your name on it. And that's the part of the conversion that people talk about. Because if they took $100 from you, deposited into someone else's checking account, and they withdrew the funds and they gave the money back to you, you'd cry bloody murder. If they gave the funds back to you as a loan, you go to the sheriff. What's the difference between depositing a promissory note and giving the money to somebody else? And claiming that the bank loaned that other person the money, but really the money came from you. Well, the difference is the economics. If I loan myself my own money, I should pay myself back the principal and the interest, and that's only fair. But if I loan myself my own money and I have to pay back a third party the principal and the interest, and they never invested a cent, that's not fair, because the wealth then goes from me to the other person for free. It's just as if my wealth got stolen. Oh, then they talk about a forgery, a forged. That's unauthorized endorsement is by definition no endorsement. I mean, that's why they try to hide that stamp. And remember this, on a check, you got to check for the 3 imposter rules about the forgery thing. Have your attorney do that. If the promissory note is lost, then the bank is not the holder of the promissory note. In other words, they'll come back and say, we don't have it, we lost it. Then they're not the holder. They don't have the rights of a holder. Again, under the Uniform Commercial Code, they can go ahead and make a copy of the promissory note. So once they make a copy, it's going to be harder and harder for them to prove it was never forged. And if the bank remember this, if the bank that originated this promissory note, if they're out of business and you can't find them anymore, you're the only one that can testify if this is a forged document or not. The people who currently have it, they can't say anything. And if you've invoiced them and you've talked to them and says you return that thing, but they still have a lien on your house and they just force you to make payments, they say, I'm going to take you into court and I'm just going to take your house from you, and you go to the sheriff and you tell them, and they won't do anything about it. See, you're forced into a situation of making payments, or they're telling you they're going to come take your house, even though you've noticed them as to this fraud. So they're trying to force you into making payments so they can say, yep, you went along with it. You went ahead and ratified the agreement by making payments. That's why some people give them a second promissory note and make payments toward the second promissory note. That way, it gives a second promissory note validity, that it has value, and you're not making payments on the first promissory note. Now you can go into court and you can start, really mucking the water up as far as a lawsuit and things of this nature. You can also invoice them. And then you can go in and sue them on the invoice. And there's different ways that I'm not going to mention right here that you might want to try. Now just remember this, you're going to get the latest information from the leader of the club. There's always some things missing in here, so you always have to go to the leader of the club. That way if people want to copy information or this, they're not going to get what they need. There's going to be something missing. This is only to teach you about expert witnessing. There's other things that you would have to know about going into court. All right, the holder of the note. The defenses fail and fall into our favor if you instruct the holder of a defense or of a fraud and the bank did not repay the loan and return the promissory note back to you. Defenses against any holder, a holder or holder in due course, there's a slight difference. A holder in due course makes it harder for you to recover your note, okay? So these are defenses against any holder. Take a look at this under the law. Number one, the person signing the promissory note because he's been fraudulently deceived as to its nature and essential terms. See, you were told that they were going to loan you their money. What they did is they stole something from you and returned it back as a loan, and you just found out about the theft. Number two, forgery. Unless it was ratified, then they can use estoppel or latches against you. Next thing is duress, illegality, and alteration. Well, they've been making false statements, so that's where you go on the illegality. All right, the next thing is cannot assert personal defenses against a holder in due course for lack of consideration, for fraud in the inducement, prior payment or cancellation. So in other words, if you pay off a promissory note, you must get the promissory note back, or the bank can keep the promissory note and still negotiate it. We already talked about that. You don't want them to come back and foreclose on you because you paid off the loan and they still have the promissory note. So take a look at, you cannot assert personal defenses. We're just talking a little bit about the Uniform Commercial Code here. Now, if you're going to pay this thing off, you got to demand you get the promissory note back. What they do is they give you back a statement saying it's been paid off, but they keep the promissory note. See, they understand the law, and a lot of times you don't. You have to be kind of careful about that. All right, there's another law book, and they go into other things too. You got to have full disclosure. All relevant information has to be known, and that's where we get them on is disclosure, disclosure, disclosure. Whether the consideration was adequate, no unfair unfair persuasion induced by undue influence. How about fraud in the execution? This is what this law course is for CPAs, talking about this. And fraud in the execution is obtaining a signature by claiming one thing when in fact there was something else altogether different than it was actually agreed to. Fraudulent misrepresentation is false statements of material facts with intent the other party would rely on those false statements. Fraudulent concealment, that's hiding and suppression of material facts to prevent inquiry, escape investigation. Larceny by fraud or deception. I want you to look at this, larceny by fraud. That's a false impression or reinforced, giving a false impression or reinforcing a false impression, or creating a false impression and then reinforcing it. So in other words, you write to the bank and you say, I understand this is happening. I never agreed to this, and we're going to have to talk about this. And they come back and they're trying to lie by lie of omission, by kind of shrugging their shoulders and knowing the truth but not discussing it. It's like fraud by silence. Okay, larceny by fraud is prevents others from acquiring the information, affecting the transaction, fails to correct a false impression. And once you look up larceny by fraud or deception. Okay, please go to the other side of this cassette tape. Please go to the other side. Okay, this is Tom Shaw. This is tape number 5, side number 2. And we're talking about the CPA and the training that CPAs have so you can help that CPA. Because remember, a lot of times, CPAs, some are involved in taxes, some in auditing, some in bookkeeping, some in management, and all different fields. And like I spent most all my time in the banking area. So a lot of these CPAs, they kind of forget about all this stuff that they were taught, 10, 20, 30 years ago. So you're there to help them, to educate them, to show them. And that's what these cassette tapes are all about in volume number 1 and volume number 2. I mean, just the bookkeeping entries are enough to really teach them, but here we want to teach you. And so we're talking here about larceny by fraud or deception. Number 1 is false impression, is reinforced. Number 2, prevents others from acquiring information affecting the transaction. So here we are, we're going into court and we're saying, Your Honor, we can prove this thing real easy. If assets and liabilities increased, we just proved our case. If the bank assets liabilities decreased, we just proved our case. If they follow the Federal Reserve Bank policies and procedures, then what they're saying is they have a policies and procedures to be involved in larceny by fraud. They will not disclose to us the truth because they know we'd never accept it. No one will loan themselves their own money and then pay back a third party the principal and the interest as if the third party loaned them their money, but the third party loaned them nothing. No one is that stupid. They have to trick us, conceal it, lie to us to get us to go along with that. And the other thing is, larceny by fraud is they fail to correct a false impression. We've written to them, we've asked them, and they're not correcting this false impression. So we got them right here. You're under larceny by fraud or deception. So you guys, this is sometimes how you have to talk to these people. So if we're putting on this mock trial in front of public, we've offered to have the bank presidents and the sheriff and the judges to come up here, or even attorneys working for the banks, and testify under penalty of perjury and tape record this. Right in front of everybody right here that has these bank loans. And the audience is going to be the judge and the jury. I don't think they're going to get very far. Now look at the difference between a holder and a holder in due course under the Uniform Commercial Code. A holder in due course, they have more defenses. It's harder and harder to take away the promissory note from a holder in due course. Now under the Uniform Commercial Code 3-305, and again, these things can change. The numbers will change every couple of years. On the different Uniform Commercial Codes, they'll have different numbers. If you look up under the state, it'll be a whole different, thing they call it. But just remember this: fraud in the execution is a defense valid against the holder in due course, according to this course that I took. And it says the party signing the promissory note had no knowledge, no reasonable opportunity to obtain the knowledge of the character of essential terms. So fraud in the execution is a good way to take away that promissory note from the best of the holders. Under the UCC 3-407, it says material alteration is a real defense if made fraudulently. Well, they have the stamp. They knew exactly what they were doing. There was no question about it. The people buying those promissory notes, they knew what the bookkeeping entries were. They knew the Federal Reserve Bank policies and procedures. They knew what the advertisement said loan instead of the word exchange. And they knew what the agreement said. It said loan instead of exchange. Under another Uniform Commercial Code book, we talk about a holder in due course. To be a holder in due course, it talks about you have to be a holder. That means you have to hold the promissory note in your hand. In other words, you didn't lose it. Number two, a negotiable instrument who took it for value. In other words, they actually gave up their money to obtain it. Well, we know that didn't happen. And they had to give value in accordance to the agreement. The agreement was they had to loan us a check for them to obtain the promissory note. No. They got the promissory note to fund the check, which was the opposite. And because it was the opposite, I mean, nearly all the property in the whole country was given to the bankers for free. And then as citizens, we have to pay them the principal and the interest and what they just took from us. And they keep on taking and keep on telling us we got to keep on paying the principal and the interest what they keep on taking from us. We'll always be in debt. We'll always be poor. We'll always be paying them interest. Our grandchildren will be paying their grandchildren interest. And anybody with any common sense says that is not a fair and equitable deal. They wouldn't reverse it and say we can steal from them and return the value of the stolen property back to them as a loan. They say, hey, you can't do that. And they can't do it against us either if we have equal protection. All we want to prove to that, judges, there's two classes of citizens, those who steal and those who are the victims. And we want to fax it to everyone in the country. So if they ever rule against us on this, we're going to say, see, that judge knows we're not under the United States Constitution. We fought the Revolutionary War to stop this. Tom Schaaf is right. We're going to have to rise up every citizen across the country to prove what's going on. So here, holder in due course. It has to be a holder, a negotiable instrument who took it for value, and in good faith. You already looked up good faith. That means no deception, no deceit, no bad faith. And they also have to, without notice that it was overdue or has been dishonored or any defenses against us or claim to it. My friends, we have a claim to it because it was unauthorized loan from us to them. They got to give it back. If it's stolen and they knew it, then they receive the stolen goods and property. All right, next thing this UCC goes on, it talks about if there's a promissory note that was stolen, then endorsed, the promissory note's invalid because the thief is not a holder, so therefore cannot endorse it. And that's per Uniform Commercial Code 3-202, and in parentheses around the next two. A thief lacks power to endorse it. So if You got a thief, take a look at the word stolen and thief. In other words, they took unauthorized control over it. So they don't really have power to do what they've done, is what we're trying to say. The way I understand this, I talk to your own attorney, ask your own legal counsel. This is to take this information to your attorney, to your CPA, and ask them what their opinion is. Ask them what their advice is. Okay, under UCC 3-305, holder in due course, real defenses. Now this is, again, going over the same thing. It's a real defense. That means such as a misrepresentation as has induced the party to sign a promissory note having no knowledge or reasonable opportunity to obtain knowledge of essential terms. It says the same thing that did 20 years ago. Or, this other textbook, 30 years ago or whatever. So you want the proof? Well, the bank refuses to tell us the terms. They refuse to answer our letters of the real agreement, and they refuse to tell us who funds the check. So they have stopped us from obtaining the essential terms and knowledge. We have a real defense, and I think we can use this now to use laches and estoppel, or to prevent them from using laches and estoppel. Okay, UCC 3-306, holder has rights unless the promissory note was obtained by theft. Well, we've been over that. UCC 1-201, and then with the parentheses around a 4, a person can be a bank. Can you believe that? Now I'm going to read off a few of the Uniform Commercial Codes. Again, the numbers might change. This goes back to my older manual that I had before I wrote the book. Volume number 1 and volume number 2, much of that is from my old manual that I had in about 15 hours of cassette tapes that I condensed into these two books, because sometimes it's easier to read a book than it is to listen just to cassette tapes. But here it is, Uniform Commercial Code 3-303, and then with an A with parentheses around the A, specifically makes one a giver of value to the extent that the agreed consideration has been performed. Loan means money, not a promise to pay, and then does not pay. Okay, number 2, Uniform Commercial Code 3-302. To be a holder in due course of a mortgage note or promissory note, you must give value and have good faith. So look up the words good faith. UCC 1-201, Part 8. There's no agreement in the absence of mutual consent. UCC 1-201, Part 364. It says, what is not money? The following is not money. A check, even when certified. So now we got court cases, we have the Federal Reserve Bank's publications, and we have the Uniform Commercial Code stating that a check isn't money. All it does, it transfers the liability from one checking account to another checking account. And that liability the bank does not pay. It has the appearance of being paid because it goes from one checking account to another checking account. But that liability is still there on the member banks, or the Federal Reserve Bank members' books. Okay. UCC 1-201, Part 362 proves that money is the mortgage note, the promissory note. The bank liability is not money, so the bank asset is the money, which makes the mortgage note or promissory note the money, which also the Federal Reserve Bank is giving validity to the same thing, their own publications. All right, some of these are really hard to find. UCC 3-305, Part 16. It says a holder in due course of a mortgage note takes the mortgage subject to such defense as the mortgagor could assert against payment of the note. End of quote. I'm going to say quote unquote again. The holder of due course of a mortgage note takes the mortgage subject to such defense as the mortgagor could assert against payment of the note. That's you, the borrower, saying to the guy who holds the promissory note, you got a problem, Mr. Bank. That's what you're saying. UCC 3-104, Part 17, it says, check is an order to pay. It carries with it the representation that funds are on hand in the bank to cover the amount of the check and that it will be paid upon presentment. It is negotiable and can circulate like money. It says like money. It is not money. It can circulate like money. Now, you got to know this if you're going to go into court. A judge is going to try and claim that check as money. He can rule any way he wants because you can get money for it, therefore it's money. And you're going to come back and say, well, under the same Uniform Commercial Code, Judge, it says funds are on hand in the bank to cover the amount of the check. Well, funds were available to cover that check, and the funds came from the borrower that the bank received and recorded on their books. And since they stole it, we have the proof, and the proof is in their bookkeeping entries, and we wanted those bookkeeping entries to prove up our case. And it's as simple as that, Judge. And if you're trying to stop us from getting the information, then you, the court, are involved in a fraudulent concealment and larceny. Ooh, they don't like that. UCC 3-101, Part 68. Commercial paper is not valid if found upon an illegal consideration or growing out of an illegal transaction. That is, a transaction which violates a provision of a constitution, a statute, or a common law, public policy, or good morals. Let me tell you something. It's illegal to take somebody from something without their knowledge, deposit in the bank, and withdraw the money and keep it. That's simple. I want to hear the judge say that Congress gave the bank authority to take something from a customer without their knowledge, having actual cash value, deposit it into a checking account, withdraw the money, and the bank is to keep it all done without the customer's knowledge. And all the same time claiming there was a contract where the borrower agreed to this. Same customer. There cannot be an agreement without mutual understanding. And the contract with the bank says there's no oral agreements. So it can only be the written agreement. So they can't go full circle and tell us what happened first, the chicken or the egg. If there's full agreement, then it has to be in the written agreement because it says there's no oral agreements. So it can only be what's in writing, the express contract. And then they can't have in a contract if they've done it by silence and saying, well, we're not telling you this. We're taking your money, deposit, withdrawing your money, and going to give it back to you as a loan. You can't say there's an agreement when the borrower has no mutual understanding, because mutual understanding has to be there to have an agreement. So if they're saying there's an agreement, then the borrower has to have knowledge, authorization, and permission for the bank to take actual cash value from the customer, deposit into a checking account, for the bank to withdraw the money and the bank to keep it. And the bank says, well, we have authorization. Okay, where's the authorization? From the agreement. Okay, show me an agreement. Well, there's no mutual understanding. There's no oral agreements. It all has to be in writing. There's nothing in writing about this. And there's no knowledge, because that's why we're trying to sue you. And you've been trying to keep this from us because we wrote to you and asked what the agreement was, and you won't tell us. So you're trying to prevent us from finding out. So there's obviously no agreement. There's no disclosure. And this whole thing is bent on disclosure, disclosure, disclosure. There was money behind the check, but you took it from us. And since you won't tell us about it, it's larceny by deception and fraud and all these other things we're talking about. And that's the whole thing. That's the bookkeeping entry, and that's the proof. And the proof, Your Honor, is there's a new asset, there's a new liability. If somebody stole a car, the thief doesn't give the victim a receipt and say, here, I took your car. They just take it. So you got to find out where that car ends up. If it's in the driveway of the thief, you know the thief took it. Well, if the bank took the promissory note, it shows up on the bank bookkeeping entries, and that's just like the stolen car showing up on the driveway of the thief. It shows up not on the driveway, but in the bookkeeping entries. And your judge, we got to have the bookkeeping entries to prove or disprove our case. My friends, that is where an expert witness comes in. And that's the value of that expert witness. Am I making any sense? I'm hoping you might have to go back and re-listen to this tape, but that was what makes the sense. You don't go talking about money, or they gave me a promise to pay money and all that, bank liability and all that. Forget that. They took something from you that you never agreed to, and that changed the cost and changed the risk of the agreements. You're always going to talk about they changed the cost, changed the risk, they altered everything, they did it upside down. All right, I want you to take a look under the Uniform Commercial Code 1-201. It talks about an agreement, means a bargain, and the language of it. Federal Reserve notes might be an implied contract. Okay? Take a look under, like I say, UCC 1-201. It demands a valid, genuine contract with a signature. I think there might be an additional, some type of contract above and beyond what this promissory note is. And I don't want to state here in the cassette tape, some of the other people in your group may know what I'm talking about on a more of a national level. And they don't want to bring this agreement or treaty into existence. They don't want to bring the national bankruptcy into existence, into that court. That judge has been told, do not allow that into court. So they got a problem right now because they can't bring in a valid agreement. Number two, UCC 1-207 gives a remedy for the common law. Everything goes back to common law. And 1-206, all statutes have to be in harmony with the common law. So you have to go into court and you have to demand what contract gave authority over you for the bank to steal your promissory note. You want to know what contract. And they can't come up with one. And they got a problem because you're going to say this thing's been forged, it's been stolen, and they illegally placed a lien in your property demanding extortion payments. Or however you want to say it. Okay, again, remember, these cassette tapes are my trade secret. It is confidential information. The only people who can be listening to these particular cassette tapes are those who signed an agreement with me, who have paid the money, and they got also a number of books, so they can go out and retail those books and get their money back. Okay? And I really appreciate you guys supporting our efforts, because when you purchase from us, it's helping us have the funds to go out and trying to get this banking system turned around, and we really need that financial support, and really appreciate you guys being honest and being supportive of what we're trying to do, because we are actually helping you. We're doing this to help you and to get this thing turned around, and we're trying to give you something of value for this information. So instead of just asking for a gift, we're trying to give you something of value, and that's what we're doing. So we really appreciate that. All right, I got some exciting things here, because I went through the original audit book that I was taught when I was in college. So you can do the same thing. You could go to a four-year college that teaches accounting, ask for their audit book, and just go down to the bookstore, get a used book. The students already highlight what's important. And it'll go through the ethics, it'll go through the different things that you have to understand as far as audit. I'm going to go through this right here. So if you're really interested, get the Generally Accepted Auditing Standards book, or this first year, it should be the junior year in college. It talks about auditing. And then when I'm done with that in this cassette tape, I'm going to go on to a course that's a continuing education course that I took just not very long ago for what CPAs would take for the continuing education. And I went right through it. I made a lot of notes. There's a lot of important things that you need to know in this, because when you're talking to that certified public accountant, they did a bank audit and all this, they had to comply to those auditing standards, and this is going to prove our case. And then there was another continuing education course for CPAs, and it had to do with fraud discovery and control for CPAs. And boy, I tell you, that's really neat, and we're going to go through that here. It'll probably be another 2 or 3 hours later that I'm going to be talking about that. And then we talk about the CPA legal liability and how they're legally liable. Oh boy, that's a beauty. And then as a bonus, we're going to talk about going right through the Generally Accepted Auditing Standard of how to audit a credit union, which is basically the same thing as a bank. Because see, the Federal Reserve Bank's own publications claim when banks, savings and loans, and credit unions grant loans, they create a lot of money. Now, when you take a look at this audit guide for credit unions, it'll show you they record the promissory note as a bank asset. Guess what? That makes them create what they call new money. So the Federal Reserve Bank is correct as far as that goes. So we're going to talk about all this, and we're going to have a lot of fun. I just got off the phone from someone down in Texas, and they're really excited about this course. There's a lot of people who want to purchase it, and the reason is because these CPAs are just starting to figure this out. And a lot of CPAs and a lot of lawyers and lawmakers and judges, a lot of them are really good people. There's a lot of sheriffs and police that are, deep down, they're normal people, okay? I mean, they care, they have families, and it's really kind of bad when just a few people know the secret and just a few people are going to benefit from it. And I believe it this way, if there's a bank loan agreement, we ought to tell everybody in the country what it is. And if a CPA did an audit, we ought to tell everyone what those audit requirements are and if they've done correctly or not, and let the nation judge for themselves. Because that's what America's all about, is the vote. So we got to let everyone know how to vote correctly and to get this thing turned around. All right, let's go over this. This is an audit book, and this is what I was taught when I was going through the university for the CPA. First of all, it explains an audit. What is an audit? An audit is an investigation of accounting information to be sure that the financial statements, that's the income statement and balance sheet. When you mean financial statements, it means the balance sheet and income statement, or statement of income, and the cash flow, or changes in financial position. Don't worry about that part. Just remember the balance sheet and the income statement or statement of income, same thing. So anyway, an audit is an investigation of auditing information to be sure that the financial statements of an entity are materially represented in a correct manner. Materially. That means it can be off by a few $1,000s. I mean, they don't look at the exact, every penny has to balance. They're looking at it as, generally speaking, if I was an investor, want to invest in this company, are things materially correct? Yes, they are. Or no, they're not. Now, in order to do this investigation, you want to make sure that you don't have biased information, and you also want to make sure the person doing the investigation is also independent. In other words, they don't have a reason to defraud someone. They don't have a reason to misstate. They don't have a reason or financial benefit to say something that isn't really true. Now, it's really hard to find an independent expert witness to testify against banks, because CPAs rely on banks for loans for their clients. And if a CPA squeals on a bank, the bank knows what accountant belongs to what business, because when you go to get the loan, the bank gets that information, and all the bank has to do is withdraw loans. And it's not like a house loan for 30 years. A business loan, a lot of times, the loan is only for every 2 or 3 months, and they got to keep on going back to the bank, and every 2 or 3 months get this line of credit renewed. Now, the American Institute of Certified Public Accountants, what they do is they redefine what is independent when it comes to a bank. See, technically, if you just went to the American population, they would probably say that certified public accountants doing bank audits are not independent. And the reason is, they know if a CPA were to say, hey, this bank's involved in a fraud, those banks would withdraw their loans from that CPA's clients. That CPA would be out of business. So therefore, the CPA cannot squeal on the bank. And the CPA many times gets many, many clients from the bank. And the bank could actually come back and say to a business, to that restaurant, you want a loan from us? We will not accept financial statements from your accountant. You have to use a CPA that this bank likes, like Joe over there on the street corner. You use him, have him do your accounting, we may approve your loan. So that's one way to squeeze out CPAs that are creating problems. When I was testifying in court as an expert witness for business valuation, when I got onto this this banking thing, all of a sudden, people quit calling me to become their expert witness for business valuation. And you think that happened by accident? I don't think so. Well, I wanted to get out of the profession anyway. My parents were saying, you're never going to want to get married if you stay, working with these divorced people. So they were, for 2 or 3 years, they were harping on me to leave that field. And I thought, this is a good time to, switch. So CPAs aren't that stupid. So I really doubt sometimes, I really wonder sometimes if they're independent. Well, the American Institute of Certified Public Accountants comes along and says, well, they're independent if they don't have a loan at that bank. Big deal. They're all working in unison. All right, let's go on. This audit book for CPAs in the university was explaining how the CPA uses the tax returns, canceled checks, vendor invoices, and contracts to investigate the financial statements. Underline the word contracts, because we're going to keep on coming back to that contract in the audit. Okay, the evidence to show the financial statements are presented fairly. You have to have evidence. They have to do some type of investigation. The auditor must have the appearance of being independent and not biased. I believe they have a real problem with that once you understand how this whole thing works. And I believe if you had a real jury of people that have bank loans and understood this, I think they would probably find out that CPA, they'd probably rule that the CPA is not independent, where maybe the CPAs would try to say they are independent. So here we have this redefinition of words. Just like the bank redefines words to make it fit what they want, I think the CPAs are redefining what independent really is to make it appear to be valid. Okay, now you have an audit report. An audit report simply tells you, it's a CPA report telling his findings of the investigation of the users of the financial statements. In other words, those people who may invest in the business or may lend money to the business. And of course, in your case, you'd be the lender. Users of financial statements are readers of financial statements. Those are the ones who are relying on those financial statements to maybe invest money. Now, there was one CPA who was a partner for a big CPA firm. I talked to him about all this. He admitted all this was a massive fraud. He was the one signing off on the audits. And he didn't know what to do. He was afraid I might come against him. At that time, I told him, I said, well, I control all the lawsuits anyway in the United States against banks. I said, if you come over to our side, I'll make sure no one sues you. So he says, I'm coming over to your side. So he gave me a lot of information. And he reminded me of the fact, let's say if you have a large bank and you invest money in that stock in that bank, you can get that CPA report and find out who the CPA is. Now, a couple years ago, I let the government know and the CPAs know that I'm going to try and put those CPAs in jail that did the bank audit, because I think they've done something wrong. If I have to become president of the United States of America to get it accomplished, that's okay. If the current government doesn't want to do it, elect me as president, and I will make that part of my campaign issue. Now, I remember a couple years ago, President Clinton passed a law making it very, very difficult now to sue CPAs. What happened was the American Institute of Certified Public Accountants and the CPA societies, they knew what I was up to. They went to the lawmakers and say, we got to pass a law so that it's really hard to sue a certified public accountant. They knew I was coming. They asked me to keep quiet, and I said, no. I said, you pack your toothbrush. I said, you're going to need it someday because I'm going to try to put you in jail. So I'm not going to be kept quiet. I'm going to get this information out. Now, some of you people, you say, uh-oh, what if they kill you, Tom? Provisions have already been made. No matter what they do, this information is going to get out, and far worse information if they tamper with me. Because if I cannot be a free American, then I'm not going to live in a slave society. It's one or the other for me. I'm not going to compromise with these people. All right, let's go back to this. It is essential for the certified public accountant to be independent and to be competent. Independent means unbiased, and I say that they are biased because they need the bank loans for their clients. Then they talk about the investigation. There's different types of audit evidence. Number one is physical examination. This means they're looking at the inventory. If I had a shoe business where I sold shoes or I sold cars, the CPA doing the audit, they got to go out and they got to look at the cars and they got to say, gee, this car has this amount of value. This car has this amount of value. And if I'm selling shoes and I buy shoes to sell shoes retail to the general population, that CPA has to count shoes of my inventory. Well, the CPA, they have to physically look at those promissory notes on the bank's books. And if they don't physically look at them and those promissory notes are not really there, because again, they said they don't have the promissory notes. You asked for the original, they said we don't have them, but yet they did an audit, but they don't have it. So they got a problem here because of this audit. And because there were some CPAs that actually got sued because on the financial statement it showed a large amount of inventory and the CPAs never counted it. So the CPAs got sued. I think they even went to jail. The next part of the investigation and the audit evidence is the confirmation. In other words, accounts receivable, that's where someone else owes you money. In this case, you owe the bank money on the promissory note. So the bank auditor has to go back and confirm with you that you really owe the bank the money. Now, they might do this in a sample. They might not talk to 100% of the people. They might talk to a small percentage of the people. But if they were to come back to you and say, do you really owe the bank the $100,000? You say, well, I've been making extortion payments, but this is what really happened according to the bank bookkeeping entries. That CPA, once you tell them, they have one huge problem. And this is why we know the CPA firms know about this, because with the lawsuits and whatever in the past, we know that they know. And they're trying to do everything they can right now to wiggle out of this, but they cannot because the agreements and the bookkeeping entries do not change. It's been consistent. And the highest law of the land is the agreement. And if you say, well, the highest law of the land is the United States Constitution, then you go back to gold and silver, equal protection and full disclosure under the alleged agreement. So either way you have them. The only thing they can really do is say, well, yeah, you're really a Washington, D.C. Citizen, and we're using bank script, and the banks can go ahead and create the money, and that one little government, Washington, D.C., took over the other states through the bankruptcy of the United States. That's what really happened. But they don't want to tell you that. But see, their bank script has no value without the promissory note. So you, at all times, the value came from yourself. So we still have them either way. Okay, now we're talking about the types of audit evidence. We already talked about the physical examination and the confirmation. Now we're going to talk about documentation. Documentation is things like vouchers. It's like promissory notes, and they talk to the maker, they talk to the borrower. It might be a bank liability showing that the bank received a loan from someone. It might, okay, the next thing would be observation. They physically observe, they're watching, they're seeing what's going on there at the bank. The next thing is they inquire of the client. They ask the clients questions, so they'd be asking you questions. The next thing is, as far as examination, is mechanical accuracy. Mechanical accuracy can be things like adding up an accounting balance, adding up numbers, things like this. The next part of evidence is comparison and relationships. Now, this is one way you can definitely get the auditor, because comparison means if there's a deposit, assets and liabilities increase. If you loan money to the bank or loan something to the bank, assets and liabilities increase. They have to know that the assets and liabilities keep on increasing as they keep on granting more and more and more loans. So they know this. They also know a bank liability means the bank owes money, that the bank received a loan. Also, comparison of relationships. It means if they withdraw money, if they loaned other depositors money, if they withdraw money, assets and liabilities decrease. If the bank receives a loan from someone, assets and liabilities increase. And You also know there must be a deposit of money in order to validate a check. And that's under the Uniform Commercial Code we just got done discussing. So if there's also a contract, there has to be an agreement, there has to be a comparison of the assets to reflect that agreement. In this case, the assets and liabilities increase. So there's two loans exchanged. A loan from you to the bank, a loan that funds, and that loan funds the loan from the bank back to you. And that's what the bookkeeping entries prove. So a CPA bank auditor must know that. That is part of the audit requirements. If they're not looking at this, that means they do not have the competence to have done the audit. If they do not have the competence to have done the audit, they get to go to jail. If they do have the competence to do the audit, then you got them in a fraud. Either way, you got them as far as I see it. Now, you're the judge and you're the jury, and I'm just presenting the evidence, and I want you to take a look at this. Now, I can just see this right now. The CPAs are getting a hold of this tape, and they're going to try and find ways to, create a problem. But I'm saying if you have just a jury right here, and if I get to present the evidence that I want to present, and there's probably a lot more that I can't put everything in a cassette tape, and I say that in case they come back after me. I think an average jury of people that really understood this, that are not CPAs, that have bank loans, I think they would be pretty upset. Okay, the next thing is, as far as this audit, well, before I even go on, I'm not trying to claim a CPA bank auditor is a criminal or they committed a crime. I'm using that type of terminology so that it's like everyday type language that people can understand. Okay? Let's go on here as far as this audit. Overall object of the audit is to follow generally accepted auditing standards. Generally accepted accounting principles. Generally accepted accounting principles. Now, generally accepted accounting principles is the bookkeeping entries. A standard set bank bookkeeping entries, just like I showed you in volume number 1. That is the proof behind everything that we're showing. Now, if you take a look at Federal Reserve Bank of Chicago, Modern Money Mechanics, it shows you about all the bank bookkeeping entries you can possibly ever want to know. So if they're going to prove me wrong, they're going to have to prove that the Federal Reserve Bank's own publication is false and misleading. So they have a big, they're going to have a big problem trying to prove that I'm wrong. So generally accepted accounting principles is the standard bank bookkeeping entries. Generally accepted auditing standards, GAAP, is the investigation part of the audit. It's like a checklist to make sure that those accounting balance, the balance sheet and income statement are materially correct. That they're materially. They might be off by a couple $1,000, big deal, but you want to make sure that they're correct. So GAAP is generally accepted accounting principles. That's the standard bookkeeping entries. GAAP is generally accepted auditing standards. That's the investigation portion. A lot of times people get those two mixed up. All right, now part of the big question is, of the generally accepted accounting principles is, that generally accepted accounting principles must follow and accurately reflect the written agreements or contracts. So you can ask the big question. You can ask that certified public accountant, according to the accounting principles, must generally accepted accounting principles follow and accurately reflect the written contracts with that company? And they're going to have to come back and say yes. They have no choice but to come back to say yes, because it's right there in the college textbooks reflecting that this answer is yes. They have no choice. Now, if they have to say yes to this question, they just got done destroying themselves in the whole audit. Their audit, in my mind, my belief, is pretty much destroyed. The certified public accountant auditor must understand the client's business and industry according to the auditing standards. You must understand the peculiarities of the business, the analytical test, that's the ratios, that means assets and liabilities increase. You must test reasonableness if the account balances. In other words, reasonableness is, if you have a deposit, you put cash as an asset with a new bank liability called demand deposit account. The same thing, just replace the word cash with promissory note, you get the same end result. So the reasonableness is who funded the check, who provided the value to fund that check. It was the borrower, not the bank. So the bank loaned no actual cash value for the promissory note. When they do these tests, they'll know that. So then they have to ask some questions. How did the demand deposit accounts, savings accounts, and certificates of deposits, that's CDs, those balances exist, or a check exists, without depositing money? See, the minute they try to answer this question, they have to answer what money is. The minute they say what money is, now you're going to ask them for the physical description. You hand them a ruler and a Federal Reserve note and say, their testimony. Give us a physical description what money looks like. Now they say, is there any other type of money? And you look at them right in the eye. Do you know what money looks like, Mr. CPA bank auditor? And if he says yes, do you know what the money would look like that was loaned to the borrower? Yes. If he says no, I don't know what it looks like, he's in a heap of trouble. If he says yes, he does know what it looks like, then he cannot have loaned credit. Because credit is a bookkeeping entry, it's a bank liability owing money, and I don't know what it looks like. He doesn't know what it looks like. There is no physical description of it. So you're trying to trick him into this. So now he says, well, gee, we loaned you $100,000. Have you ever seen the $100,000? No, I haven't. Do you know what it looks like? No, I don't. If he says it looks like Federal Reserve notes, he just proved up he has a big problem. Because they loan nothing to obtain, no legal tender to obtain that promissory note. And if he says, well, I don't know what money looks like, then how could he have done an audit, and how could he have known that the money was loaned to obtain that promissory note? Now, if he says, we know we loaned no money to obtain the promissory note, then they have to agree that that written agreement was not fulfilled. Because that written agreement says there's no oral agreements. See what type of problem this CPA is involved in? All right. Let's go on here. The CPA must understand the client's business. They must understand the overall of the client's legal obligations. There's a whole section in the audit book on this. So they have to understand the legal obligation. This means the written contracts, the written agreements, to see if the bank legally fulfilled the loan agreement and legally owns the promissory note. You cannot sell a promissory note until you legally own it. And you don't legally own it until you gave consideration in accordance to the agreement. You cannot deposit and withdraw without the client's knowledge, authorization, and permission. And you must review the contracts and agreements to be sure the bank's financial statements accurately are stated. And you also must evaluate management for possible fraud. This is all part of the audit. And if they did not do this, they have one huge problem. So if they did it, they're going to have to be able to explain it to you, and you want to look at their work papers. Work papers, that's like their notes, what they wrote out, what they did during the audit. Boy, they're in one heap of trouble. All right, we're going to go on to cassette tape number 6 here in just a moment. You guys, I'm really proud of you, because as you're learning this information and you're starting to understand what these audits are, you're going to a CPA and you can talk intelligently now to that CPA. And as we get these CPAs turned around, boy, we can really get this country turned around. I think the key is the CPAs and the lawyers and the voters. Okay, let's go on to the next cassette tape.